People v. McGovern.
Good morning, good afternoon, Your Honors. May it please the Court. If it pleases the Court, I would request 2 minutes of time for rebuttal.
Yes.
I'm Jeremy Schwartz. I represent the appellant Randall McGovern. As an initial matter in this case, the people do acknowledge, it seems, that they do have the burden to establish in a case such as this, where counts 1 and 2 of the indictment were the same occurrence, that prima facie evidence has been put forth, and it is now the people's burden to show that these are separate offenses under 70.25. They are not separate offenses. They are not separate acts. They are not separate under really any of the framework that has been put forth. It would be actually pretty difficult to...
So here, the forgery and the larceny are the same act?
Yes, because the act of forging the document was the false pretense for the larceny.
Couldn't you forge something without the larceny aspect of it?
Well, in a lot of cases you could, but in this case, grand larceny has a lot of different theories, and under the grand larceny theory of, say, a simple taking, yes, you could have two separate offenses where you take property. That's why the people cited Day, and they spend quite a bit of time on the framework of Day, this court's 1989 case, sort of suggesting it's an element-by-element analysis.
In this case, the tires were in the defendant's truck, right, before he even signed the invoice.
Well,
So wasn't that larceny over at that point?
It's not clear whether they were before or after, but it doesn't matter in this case because the theory...
I think it does matter. If they were in his truck, the larceny's completed.
If it was charged as a taking, but it was charged as a larceny by false pretense. So the fact that it was charged as a larceny by false
Well, the false pretense is complete. I'm not understanding you.
The false pretense,
Getting wrong information to get them to, excuse me, to go to this place, to put the tires in the truck. The tires are now in the truck.
and the false pretense is the signing of the invoice. That's the manifest.
No, that's the forgery.
Well, that's the forgery, but it is also the false pretense.
But it's a separate crime of forgery. I agree with you that sometimes it could coincide that way, but not in this case.
Well, it seems that it did. The facts are not clear if the tires were all on the truck before or after. But again, as charged to the jury, as the theory of the people in the case, the theory of the indictment, the act of the false pretense was required for the larceny. It was not the taking. If they had charged two separate counts for the larceny, if they had charged under separate theories, if there was a count 1, the taking of the property, and if there was a count 2, the false pretenses larceny, and then if there was a count 3, the forgery, then perhaps counts 1 and 3 would be incompatible or would be separable for purposes of 70.25, but they're not. The theory of the case, as the jury was charged, the jury was told that they have to find that there was a misrepresentation of a prior fact. There's no evidence that the individual said that well, there's evidence that the person believed, perhaps, that the individual that took the tires was Joe Basil Jr., but if he didn't sign that invoice, then he wouldn't have left with the tires.
How do we know that?
Well, because I guess that would cause a whole slew of other offenses, maybe, of him speeding away or something along those lines. But it doesn't make sense to think that he would sign, there would be no purpose in the person, if he'd refused to sign the invoice, for example, and said, okay, I've committed this grand larceny, but I'm going to refuse to commit another offense of forgery by signing this, it would have been a simple matter.
So how come the false pretense can't be the exchange before that? You know, when the instruction is given to call the cell belonging to Joe Jr., and he calls, and there's instructions given to deliver it to a particular place.
Well, because it's not, then perhaps it might be an attempted larceny at that point, because it is not clear that the tires, the signing of the invoice and the tires were it's not exactly clear what order those were in. He came with the invoice, he came with the tires, he assisted in moving the tires from his truck to the defendant's truck. The defendant maybe moved some of the tires. It's not exactly clear who moved the tires, which tires, or whether the invoice was taken out and signed prior to those tires actually being in the custody of.
But do we have to think it's necessary for the act to be completed with the signing of the invoice to agree with you? In other words, if the transaction could have taken place separate from the signing of the invoice, then presumably you have a much harder argument to make, right?
Yes.
Okay, and so it seems to me we have to view the record as indicating that the act could only have been completed and was completed with the signing of the invoice. Is that fair?
It was, because that was the manifestation of the false pretense.
But if the record didn't suggest that, then it would be otherwise.
Right, if the record suggested something different, that is possible. But in this case,
What's all the rest of the scheme then, if it's not false pretense?
you mean the scheme?
What got the gentleman to bring the tires to this place to begin with?
Well, he was told to bring the tires by an owner of the tires, and yes, there were some things were put into motion. That is true. But that was not the entirety of the larceny. Again, this was not charged as a larceny by taking. It was charged as under the alternative theory of a false pretense. That's the way it was charged. That's the way it was told to the jury. The jury had to find that there was a misrepresentation of a prior fact. The language is very similar.
Doesn't he claim to be somebody else representing a different company to get the person to drive the tires down to him?
Well, that wasn't all established. In fact, all that was established is that they did not establish who exactly made all of the other phone calls. What they established is that the person that was there was identified as the defendant. Whether he was involved in any of the prior machinations is not known. That was not part of the proof. The only thing that was shown was that, for example, it could have been really something Joe Basil Jr. did want. And somebody else intercepted that and jumped in and decided it was going to sign Joe Basil's name. That would require, that act is necessary, again, under the false pretenses theory as it's indicted. It was not indicted as just simply taking. But again, we don't know whether they were taken before or after the signing. If it wasn't, and I understand that could be a distinction that the court would weigh, but the proof doesn't say that. I don't know that the person remembered for sure whether he had, and again, this is getting into some of the I think this is getting a little too into the facts of what the jury may or may not have determined. We don't know that the jury determined that the tires were put on first and the invoice was signed later. All we know is that the jury, based on the charges as charged to the jury, all we can infer from the jury's verdict is that he signed his false name to an invoice, and that caused the taking of the tires. So we don't know whether we don't know if the jury made that finding, that the tires were put on before or after. Certainly, if he came out of the truck, if the delivery person came out of the truck with the invoice and said, sign this invoice, and the defendant refused to sign the invoice, he would say, too bad, no tires, what are you talking about? Or make some phone calls to nix the deal. That was required. If there was no invoice and the defendant simply took the tires off the truck without even mentioning anything and left, that would be a taking. But it was not charged that way, and we don't necessarily know if the jury made any sort of finding, whether it was before or after.
But you keep saying we don't know, but in order to accept your argument, we'd have to believe that it happened the way you say it happened.
No, because the people have the burden. The people have the burden of showing that they're separate. So to say that it happened in some different way that would require separate sentences?
So
or-
I mean, I guess I'm confused about how they would know to deliver these tires if the call didn't come first, somebody pretending to be Joe Basil, ordering tires, delivering them to a place, and then getting an invoice signed. It makes no sense to me otherwise.
Well, we don't know who did all that, and we don't know that whether the jury found that the false pretense was that, or the false pretense was him signing the invoice. And again, that's the burden of the people, because it is the same occurrence. Whether it was one tire before, all tires before, some tires after, we do, and again, I think this is getting too much into the facts, and I don't think the people can establish their burden because of that, but we certainly know that the individual who gave the invoice to the person he identified as taking the tires said that he was literally leaning on the truck. He used the truck that the tires were going to be put on, or were put on, or had been put on, but hadn't left yet.
But there are circumstances wherein, during one occurrence, one can commit more than one offense. You would agree with that?
Oh, sir, absolutely, and that's a distinction that is put forth in Day. In Day, it was checks that were stolen, and checks ultimately also became the forged instrument. But the checks that were stolen were the grand larceny, and that was the taking. A person took hundreds of $1,000s worth of checks. Later, they modified the checks so that they could cash them. So that was the forged instrument by the modification of the checks. So that's a clear example of where that can happen. In a lot of cases, there's a lot of jurisprudence around firearms cases and assaults or homicides, where someone who possesses a firearm brings a firearm to an incident and then uses the firearm to shoot someone. That person might be guilty of the assault by the shooting, and also criminal possession of a weapon by having a loaded firearm that they brought to a situation. But like this court said in Hamilton, it's not always the case either. A person could concomitantly have a gun. The facts of that case are not clear because the facts aren't necessarily fleshed out in all of these cases. But in Hamilton, notably the 2005 case, this court indicated that the intent actually matters. Now, the respondent does a lot of work in their brief implying or somewhat urging the court to find the intent does not matter, that the intent of the two offenses shouldn't matter at all, but this court said it did. In Hamilton, it said that the possession of the weapon, now, I can presume from the finding in this case, but I don't know, that the firearm that was used to shoot the various people in that case was at least not proven by the people. Again, this is showing that it's their burden, but at least not proven that he had the firearm at any point prior to the shooting. That he got the shooting, his intent manifested to shoot at the exact same time he possessed the gun. Here, the intent is obviously inseparable. There is no reason to have this invoice unless you're going to steal those tires. And under Hamilton, the intent is inseparable. Under the facts of the case, depending on how important they are, the people cannot establish their burden that there is a separation here enough to overcome 70.25 sub 2. So if there are any questions, I would ask the court to reverse.
Thank you.
May it please the court, Michael Hillary appearing for respondent, people.
Mr. Hillary, can you establish what is the evidence that establishes they're two separate offenses here?
Well, first, Judge, I appreciate the question. I believe the evidence, in fact, does factually establish that these were two separate offenses. As to the question of when the tires were unloaded from the express tire truck and loaded onto the defendant's trailer, I think the record is clear with respect to my adversary here, pages 750 to 753 of the record. Mr. Michaelek testified that after the unloading and loading had taken place, he went to his truck, he received the invoice, he presented the invoice to the defendant, and the defendant signed it, Joe Basil. I would also submit, Judge, that the forgery in this case was extraneous to the grand larceny.
So when was the grand larceny completed? When the tires were done being loaded on?
The moment they were moved, even slightly, that constituted a taking, Your Honor, so yes.
And if we were to agree with you, do we have to read the record to indicate that, well, let me put this differently. If we concluded that the signature on the invoice was required in order to complete the taking, then it seems to me your adversary would have a better argument, right?
I agree, he would have
Okay,
a better
so
argument.
what in the record shows us that the signature on the invoice was not completed, and what exactly is the false pretense?
There are, to be sure in the record, many false pretenses here, or false representations of an existing fact which occurred well before the forgery occurred. So the moment that the defendant calls Express Tire and speaks to Ms. Rule and represents that he is Joe Basil and that he is requesting a certain type of tire and a certain quantity of that tire, he has made a misrepresentation or a false representation of an existing fact.
And do we have to conclude that, in fact, the tires would have been delivered based on that representation, or is the fact that it was made enough? In other words, if the tires wouldn't have been left behind without the invoice, what then?
Well, if they wouldn't have been left behind without the invoice, I think that underscores that the
Wouldn't that mean
Let me go
that, wouldn't that mean that the larceny wasn't completed till the invoice was signed?
No, Your Honor, because the invoice is extraneous in this. If we look at the testimony, we look at the record, and we hear from Mr. Michalek about the nature of the invoice. This was not a document meant to establish the identity of the person receiving the tire. There was no identification requested of the defendant to confirm that he was in fact Joe
So
Basil.
what was it meant to do in your view?
Well, according to the testimony in Mr. Michalek's testimony, the purpose of that was inventory, keeping track of inventory, creating a record of the transaction, allowing the customer to have proof that the transaction occurred, that he received the tires. So that is independent of whether or not the person who is signing the invoice is in fact the person that he purports to be.
I'm sorry, I thought your statement earlier was that the larceny was complete when the tires were moved.
Yes, Your Honor.
So then why would it make a difference if that's signed later, if the larceny's already complete, right? So that's signed after, assuming that you're accurate in your description of the record. That's signed after. So it seems to me if the larceny's complete when the tires are moved into the defendant's trailer, wouldn't that mean that there were other representations that led to that transfer? Right? I mean, it's based on something else than the invoice. It seems like it hasn't been signed yet.
Absolutely, Judge. Our position is, in fact, that the representations that were made, the oral representations, both on the phone some 4 times before the meeting occurred, up to the point where the two are now face-to-face in this lot, and the individual, the defendant, is telling him that I'm an employee of the Joe Basil family. Those representations in and of themselves are sufficient here to constitute the false misrepresentation of a fact, and that was sufficient to trigger the actual taking of the tire, or the delivery, and then the taking by defendant of the tires. So under the Laureano framework, and there is material overlap here, is what I take it counsel is arguing here. But under the Laureano framework, even with that material element overlap, this court can go to the record and determine whether or not there were facts presented by the people that supported the forgery as an independent, separate act. And I believe the people have accomplished that. There is no need that the jury, it be established that the jury would have interpreted that way. It's simply whether or not those facts are available in the record to support a separate act, independent of the grand larceny. I would also, Judge, or Your Honors, I would bring up one other case, and I apologize, I thought of this well after my brief was submitted, but it's an interesting analogy, I believe, in this situation, if I may. And that is People v. Rodriguez from 2015, this court's decision. The site is 25 New York 3rd, 238. Our position essentially here in this case is that the forgery was extraneous. In People v. Rodriguez, it involved consecutive sentences for an assault and a robbery. Factually, what happened was the defendant and co-defendants confront the victim on the street. Defendant puts his gun, or shows his gun to the victim, demanding the victim's gold chain from around his neck. The victim starts to comply. He's removing the gold chain. And defendant, while the victim is already complying with his order and the show of force, shoots him multiple times, interrupting the robbery with an assault. This court found that consecutive sentencing in that situation was appropriate. The defendant had argued, of course, that the show of force, the shooting was consonant with the show of force to advance the robbery. They were essentially one and the same. But this court said, no, that was extraneous force. The assault was unnecessary. The force that he had shown the defendant in the display of the gun was sufficient to establish that coercion and to lead to the effect of the robbery. This is very similar, I think, because what we have in the forgery is extraneous in the sense that now the defendant is continuing the deceit, but the deceit has already happened multiple times through multiple false representations of fact, and all of the phone calls preceding that transaction, and even at the site when the defendant says, I'm Joe Basil Jr., and then ultimately signs. It had already been accomplished, so the forgery was simply not necessary. They're separate and distinct. And unless the court has any other questions, I'll ask the court to affirm and thank the court for its consideration.
Thank you.
And just briefly, respondent again says that the larceny occurred when the tires were taken, that it's the taking. It is not, because that's not how it was indicted. In fact, in this indictment, the second count not only says,
No, but isn't that the charge? I mean, isn't that the way the jury is charged? Said you have to wrongfully take, obtain, or withhold such property from the owner of that property, and then goes on to say definition of larceny by false pretenses involves obtaining possession to the property as a result of the owner's reliance upon the misrepresentation.
it does. And
Obtaining possession, that's it. And if the tires are moved and put on the truck, defendant obtained possession.
So even if the grand larceny could have been completed, say the second count was never even charged, and the grand larceny, the tires were possessed in whatever way they were, and it was by a false pretense, the second count must go concurrent to that, because that count, it's the invoice number is in the second count of the indictment. The invoice states those tires. It doesn't state anything else. So whatever other misrepresentations there were, they were, at least the second count, the act in the second count of signing was at least part of the act of the grand larceny. So even if the grand larceny can stand on its own, count two cannot. So count two has to go concurrently under 7025, has to go concurrently to count one. And with that, I would ask the court to reverse. Thank you.
Thank you.